Judge is dismissing a transgender woman's lawsuit against the Miss United States of America pageant. Federal judge on Thursday threw out a lawsuit by a transgender woman who accused the private pageant corporation of discrimination for denying her the right to participate in competitions. U.S. District Judge Michael Mosman found that the Pageant Association cannot be required to allow a transgender woman to participate in light of its mission to promote natural born females. So the judge, this is out of federal district court. We're going to go through a couple things here. We have the motion, the memorandum that was filed by the defendants. We do not have the lawsuit, the underlying lawsuit that was filed by Anita Noelle Green, who is the transgender individual who was suing Miss America. So let's just get the parties straight here. We have the Miss America pageant, which is the defendant. They are being sued by Anita Noelle Green, who is transgender, who is now basically saying that Miss America has to host transgender candidates or applicants to go through the process. Miss America now is saying that, no, we want to maintain natural born females. That's the sort of the mission. That is the expression. That is the conversation that the Miss America organization wants to have. Anita Noelle is saying, no, it shouldn't just be natural born. It should also include transgender individuals because this is discrimination. This is bias. So now that we know who the parties are, let's go back into the story. We have U.S. District Judge Michael Mosman, so the judge of the court, said that the Pageant Association cannot be required to allow a transgender woman to participate because they have a mission to promote natural-born females. Judge said, I view it as an association that cannot, under the Constitution, be required to allow the plaintiff to participate in what defendant says is a contradiction of that message. Anita Noelle of Clackamas said she was disappointed in the ruling, but that her suit drew attention to an important bias, even if it was not ultimately successful. This case brought awareness to an issue many people were and still are unaware of, and that issue is that discrimination against transgender people is still actively happening in private and the public sector, even within the pageant circuit, Green said in a statement. Attorney who represented Miss United States praised the ruling, says, my client is not transgender, but it just wants to be able to hold a pageant that is only for biological females. I'm sorry, my client is not anti-transgender. Contrary to what people think, my client, the pageant, is a supporter of diversity. It believes there can be a Miss Black USA pageant, a Miss Native American pageant, or a transgender pageant. Green holds the title of the 2019 Miss Earth Elite Oregon, and she competed in the 2018 Miss Montana contest. She applied to participate in Miss United States of America national pageant, but her application was rejected. The policy, intentionally designed to exclude the specific class to which the plaintiff belongs, transgender females, is discriminatory because it denied plaintiff the full and equal advantages and privileges of the defendant's services in violation of Oregon Public Accommodations Law, her suit alleged. Shanoa Payne, Green's lawyer, argued that the pageant is predominantly a commercial business that granted minimal protection as opposed to expressive association protected by the First Amendment. So you see what we're doing here. We're taking out these two legal concepts. What Miss Noelle, Anita Noelle, is saying is this is a private business, yes, but it's a commercial business. And so we're talking about asking them to do things that don't impact the foundation of their company versus expressive association, which is protected by the First Amendment. So they're saying, in other words, that the heart of the pageant is about, I guess, putting people on stage and seeing if they can win the contest according to the rules of those contests. It has nothing to do ultimately, fundamentally, with it being biologically female. It's just a pageant. And so what Anita Noelle is asking is to say, this is they're not afforded any First Amendment protections. They're afforded minimal protections. And so we can't hold the standard to be sort of a strict scrutiny First Amendment legal analysis. It must be a lower standard. So we can actually modify. We can tell Miss America, nope, you got to let them in because it's not impeding. It's not impugning the core fundamental basis of why they exist. They're saying it's to sort of support and have competitions for biological females. on the other side, Anita Noelle is saying, well, it's not about the biological female part. It's just about the competition. And depending on how you categorize it, you can have two different standards, and that's what this article is talking about. We have minimal protection versus expressive association. The national pageant's exclusion of an entire class of individuals, transgender women, quote, is not message-based, but it is status-based, says Payne, which is Green's lawyer. Green holds the same viewpoints and goals as the Miss United States of America pageant, quote, which is to promote and uplift women, and she wants to advance their goals. Mosman found that the national pageant, the judge says, it's predominantly an expressive association. So the judge is saying kind of what they do there is they express things, they talk about things. And so under that categorization of what the pageant is all about, they get more of the First Amendment strict scrutiny analysis, as opposed to the company of Les Schwab, which has a simple, entirely commercial message that is to, quote, buy our tires. The pageant corporation, both nationally and locally, is primarily engaged in expressive activity, not substantially commercial. Because I viewed it as an organization that does not promote a message and seeks to maintain control. Because I viewed it as an organization that does promote a message and seeks to maintain control of that message, I view it as an association that cannot, under the Constitution, be required to allow plaintiff to participate in what defendant says is a contradiction of that message. He goes back, he's referencing the Boy Scouts of America case in which the nation's highest court ruled that New Jersey couldn't enforce its non-discrimination laws to force the Boy Scouts to allow gay scoutmasters. The Supreme Court reversed a lower court decision that ruled in favor of allowing James Dale to serve as an assistant scoutmaster. Green said she viewed the ruling as a minor setback, would be exploring other options. She said that Miss United States of America pageant, quote, is on the wrong side of history for choosing to actively discriminate against transgender people. But the road to creating meaningful change has always been a long and bumpy one. In court papers, the lawyers questioned the pageant's so-called mission, noting that Miss United States of America pageant has, in fact, had a man dressed in drag serve as a judge, and that minors have been provided with alcohol at a 2019 Miss Oregon competition as part of the United States pageants. The pageant corporation said it would investigate the alcohol allegation. Camp, its lawyer, said once the issue of a man dressed in drag serving as a pageant judge was brought to the pageant's attention during litigation, it prohibited the man's future participation. So they've been somewhat consistent about it. Green said she won't let the ruling change her stance. Transgender women are women, she says. My message has always been consistent, and my message is this: every person has beauty. So let's dive into the lawsuit. Actually, this is the defendant's motion to dismiss and a supporting memorandum of law. You can see here Anita Noelle Green suing Miss United States of America Nevada company, filed by Camp. So now this is a 54-page document. We're not going to go through the whole thing. This was filed back in mid-February, and the judge recently dismissed this claim. Let's go through it. Let's just show you what their arguments are. So we already know sort of what Anita Noelle's claims were, that the fundamental reason for the Miss America pageant is to have a competition to find out who the next Miss America is. And since transgender women are women, they want to participate in this competition. Sort of their claim. Any rules that prohibit them from doing so are discriminatory, and they're not inclusive, and that's a violation of anti-discriminatory laws in the United States. This is the Converse argument. This is what the defendants, Miss America, are saying. And this was the motion that ruled the day. This is a civil action for the alleged gender identity discrimination, which was brought under the Oregon Public Accommodations Act. Plaintiff is a biological male who identifies as a female, claims she was wrongly discriminated against because the defendant did not allow her to enter its beauty pageant. This is limited to natural-born biological females. So this is going to be an interesting claim, right? This is going to be an interesting thing. We may see more of this in sports unless that last act actually passes. We talked about the Equality Act, which just passed the House of Representatives. Now it's going over to the Senate, which makes these types of claims have a lot more teeth because it's now baked into the Civil Rights Act of 1964. This is where they're talking about gender identity, sexual orientation, and I think sexual identity. And there's a whole category of new protections that would be written into the 1964 rules if the Equality Act passes the Senate and Joe Biden signs it into office or signs it into law. Under the federal rules, the defendant, here the pageant, moves to dismiss the plaintiff's complaint for failing to state a claim. That is because holding the defendant liable would be, as a matter of law, a violation of the rights of free association and free expression contained in the First Amendment that have been interpreted in the controlling U.S. Supreme Court cases below, Hurley and Dale. Within the complaint, they know that their pageants are called Miss United States of America. That simple, undisputed fact. And the First Amendment rights of free association and expression, and Hurley and Dale in the Supreme Court, hold that these constitutional rights preclude liability through a State Public Accommodations Act under similar circumstances. It dictates the dismissal of this case, and the judge agreed. Holding the defendant liable, holding the pageant liable, would violate the same and even broader free expression and free association rights in Oregon's Constitution. Dismissal is appropriate because the plaintiff cannot cure the complainant by alleging additional facts. The pageant promotes, celebrates, encourages biological, natural-born women by performing pageants across the country. They want to uplift everybody. To achieve its mission and promote its message of biological female empowerment, defendant has eligibility rules for contestants, including application deadlines and things like that. And they say these rules are essential to create an equal playing field for all female contestants and to promote defendant's message of what it means to be a woman, a biological female. So this is one case in federal court, in one court in this country. We're going to see other claims like this, I think, here in the very near future. One we had talked about in a little bit of a different context, one that we're seeing in sports specifically. The Department of Justice, which was helping 3 women who are, I think, bringing high school claims. I forget what state that came out of, but during the Trump administration, they were supporting these claims, saying that these high school girls were denied access or denied certain privileges because they were losing competitions, because transgender women were now beating them in their state tournaments. And that lawsuit was being supported by the Department of Justice under the President Trump. Now, not so much. They are dropping that and they're passing the Equality Act. But this case lays out a bit of a framework for other lawsuits. And the question is going to come down to, is it commercial or is it expressive? This judge says if it's expressive, then that is protected by First Amendment rights. In this case, the analogy here is that this is a pageant that is an expression of something, and that is protected. So they dismiss this claim. Well, could you make that same argument on a track field? I'm not sure, but I am sure somebody will bring it up. But according to the plaintiff, a man who identifies as a woman, defendant must accept plaintiff, even though the plaintiff missed the application deadline, and any other man who identifies as a woman into its biological female-only competition, or defendant discriminates based on gender identity, violates the act, faces crippling damages, attorney's fees, mandatory training, and injunctions. So they were asking for a lot in that complaint. Plaintiff, they say, does not seek equal access, but seeks to fundamentally change the defendant's mission, alter its core message, take away a level playing field from biological women competing for a pageant's crown. Oregon law does not allow this. Plaintiffs cannot use it to co-opt defendant's message, undermine its vision, or violate its constitutional free speech or free association rights. They say that this fails as a matter of law. Plaintiffs filed this suit too late. First Amendment of the United States protects against this lawsuit. Corresponding provision of the Oregon Constitution also protects the freedom to express the message of its choosing, not the message the plaintiff demands and can easily express elsewhere. This court should dismiss the complaint with prejudice, and the judge ultimately did that. In conclusion, the defendant wants to promote, celebrate, or encourage biological or natural-born women around the country. If plaintiff's demands are met, not only defendant, but speakers of all sorts, from large television and film studios to local theater groups, would be forced to speak and associate with messages they oppose. Both they and their audiences would lose out on distinctive messages, challenging our beliefs, exposing us to newer, different ideas. This court should not allow that to happen. It should uphold the U.S. Constitution, follow Hurley and Dale, and dismiss the complaint with prejudice. And the judge ultimately agreed. And so I'm going to guess that this issue may be appealed if Anita Noelle can find funding to appeal it, but we'll see where that goes. Let's jump into the questions over from locals.com. Robert, why can all the LGBTQ have their own pageant, sports, and leave the straight alone? That comes from Bumalickit. Well, I don't know. This issue is a tough one. I don't know the answer to that. I don't know why. I think that their argument is because that is, analogous to separate but equal. They're saying that that is segregation, that they are not different, that a person who is born biologically male, who transgenders, is no longer a male anymore. They are 100% fully female, and to discriminate against them in a Miss America pageant apparently is discriminatory. Judge didn't think so, but another judge in this country certainly will, I'm sure, down the line. We'll see where that goes. CA Java Bean says, and will an equity demand be next if a transgender woman does not win the pageant? Good question, Java Bean. Good question. Equity demand. I like that framing of that. Because that's kind of where things are going right now. I think I saw a headline on the Drudge Report that Obama is now, considering reparations, and we're having this conversation about not so much about equal opportunity, whether we all should be starting at relatively the same spot, but whether we can now impose equal outcome. Now whether we can say, well, we're all, 35, 45 years old, whatever it is, and you're entitled to more of an equal outcome than you have. And so now we're going to make sure that we can level this all out. The people who are too high, we got to smash down. People who are too low, we got to bring them up. And so equity demands. I mean, I don't know why. I mean, if you want to just keep playing that game, I think that is the logical extension of this thing. Okay, what if they admit her and she loses and she says, okay, well, that's because all the judges are transphobes, and sues them for systemic equal opportunity discrimination, whatever that looks like. I'm going to guess that is coming. Stookie says, if, quote, private social media organizations can censor speech, then why can private pageant organization not set its own standards as well? It's a good question, Stookie. I think that the answer here is, you're illustrating just a massive hypocrisy that exists. I think that is very accurate, and it's fun to point out. I think that also their response to that would be that social media organizations are private companies that censor speech. They're allowed to do that because it's in the interest of preventing harm. It's preventing danger, right? That's the justification for all the censorship. Dangerous information, lies, fake news, insurrectionist, white supremacy, sedition, and on and on and on we go. Right? That's their justification for that. On the other side, they're saying this is not dangerous. This is a civil right now. So they're sort of lowering the line on the free speech allowance. They're saying, nah, you don't get that much free speech, but we're upping the civil rights issue. So they're sort of picking their battles, and they're justifying them from both sides. And we'll see where it goes. This judge didn't buy that argument. We have Get Some Skate says, not sure if still true, but the pageant would disqualify any woman if it were found out they had plastic surgery. It is the pageant's brand to promote beauty, intelligence, and natural women. I didn't know that. I don't think I've ever watched a Miss America pageant. I don't think so. I didn't even know if it was really a thing. I thought it was kind of it was a Trump thing, right? Didn't he do that? Jen McClellan says, Robert Gruller, what would the correct pronoun be for a transgender winner? Would they have a separate changing room? So I don't know. I think that they would be called Miss America if they won. If they let them into the Miss America pageant and that individual won Miss America, I think she would be Miss America. A biological male, but transgender and identifying as a female. And if that were allowed under the pageant rules, then she would be Miss America. And the separate changing rooms issue, I don't know. Right now, I think that probably. But in the future, if the Equality Act passes, which it probably will, then if she wanted to be in the same dressing room, she gets access to that same dressing room, because anything else would be a violation of the 1964 Act that has been being amended by the 2021 Act. Nadarb says, Robert Gruller, in the United States, approximately 0.58% of the adult population identifies as being transgendered, according to data from 2016. When breaking down the transgender population by state, DC has the highest percentage at 2.77. All states in the U.S. have transgendered adults accounting for less than 1% of the adult population. Yeah, I know. That's kind of my experience with this, just in general, just sort of living in the world. It's not a common thing in my experience. I think the response to that is, well, that's because of this systemic, patriarchal, privileged, whatever, and people are not coming out. You know, that percentage would be higher if more people felt empowered to do that, to come out and own their existence, own their identity. I've seen that response. I've seen this argument with just general homosexuality, right? That the numbers are going up. And I've seen this argued both ways, and I think it's interesting both ways. One is that sort of the public acceptance or the public integration, let's say, of homosexuality, which has been disfavored in this country for a long period of time. We have some sort of, I would say, updating with the times developments in this country. We have the Obergefell case and its progeny, and it is becoming more acceptable, more traditionally normal, not an issue anymore so much. I mean, in my generation, I never really thought it was a huge issue in general, at least I would say in the last 5 years, 10 years maybe. But that's not my experience. I don't live in that world, so I don't know. I could be totally mistaken about that. But my point here, to go back to my original concept, I saw this debate going on Twitter where two people were trying to explain away why we're seeing homosexuality numbers in this country rise. Well, why is that? Well, one person said, well, it's because more people are coming out. It's safer now. They can come out and express themselves fully, which is good. We want people to be able to do that. I want people to live their lives. I don't want people to live in empty shells where they cannot express themselves fully. Authenticity is one of the highest values, I think, in this world today. I think being authentic is critical to living a fulfilled life, and I want more people to do that. Be authentic. So the opposite response from I would say some more of the traditional social conservatives was, it's not about people coming out. It's about society indoctrinating individuals to think that they are of that disposition when in reality they are not. Two very interesting perspectives, and I don't know. Transgender argument, I think, would apply those same concepts, right? They would also be arguing, it's probably not 1%. It's probably like, 10%, but they just don't know any better. Or we as a society have been indoctrinating them into one particular gender identity, and we have to stop that, which is why I think you have Dr. Rachel Levine, who's now, I think, the deputy health secretary for the Obama administration, getting into it with Rand Paul, saying, what about the kids? Okay, what if you have a 7-year-old who thinks I might be female? Do you start pumping them full of hormones? Right? What is the next logical extension? If the issue here is that there would be more transgender people identifying or transitioning if we started them earlier, because to not do so would be to box people in. Okay, so if that's true, well, what's the next alternative? Well, the only logical extension of that would be to have conversations with people when they're younger about what gender identity they are. And what does that lead to? What conversation does that, where does that go? Ultimately, though, I agree with you, Nadarb. I have not seen this largely in my life. I don't know why we're sort of killing each other over some of this stuff. Bathrooms here, locker rooms there, sports here and there, when I think that there are a lot bigger issues. Ma Fox says, sounds like winning a pageant is not the same as the advantage provided to naturally born males. I say if they follow the rules and manage to win with that severe disadvantage, by all means. Yeah, so I think that's a really good point, actually. If it's a little bit different than the sports. So with sports, right, men, in my experience, unless you're talking about, gymnastics or something, right, men traditionally have better performance outcomes in sports. They run faster, they hit harder, they jump higher, they lift more, everything's more advanced. Okay, that's why we have clear delineations between the WNBA and the NBA. But if you had a woman who could just go and crush a bunch of men in the NBA, why don't you just go let her play in there, right? because there's a clear difference. Men and women have biological differences. I think. Are you allowed to say that? I don't know if you're allowed to say that. But I just said it, right? There are differences. That's why we come out with different genitals, because we're biologically different. Now, you can talk about gender identity and where that all evolves into, what that conversation evolves into, is beyond the scope of what I want to get into today. But Ma, I think your analogy here, if you have a male who's transitioning to female in sports, they're going to have a distinct advantage. They're going to run faster, hit harder, jump higher, whatever. But if you have a male transitioning to a biological female in a beauty pageant where women are structured to have an advantage, let them, right? Let them in. All right, sure. Come on in. We'll put you up there with all of the other women and let's see what happens here. So, it would be very interesting if they won because of the judges or the political, environment. People just said, oh yeah, that's great. We're going to, I think that actually could happen, right? I actually think there's probably a high likelihood that happens, if I can be fair about that. If she got in, she'd probably win it because people would be very, very hesitant to not vote for her because of the political blowback. So now you might have some claims from other biological women who are concerned about this. You may have, if she does get admitted into the pageant and she loses, I can basically guarantee you that there's going to be some other lawsuits that come down. Well, there are structural differences here. They didn't give me the right locker room. That judge is a transphobe. This room or this structure or something is just not up to par, because the argument here that they're trying to, I think, utilize is this separate but equal stuff, which is a pretty bad argument, right? I mean, separate but equal, I think, is not a good argument because of the historical connotation from which it is birthed in this country. And so, you got to be very careful when you are trying to talk about solutions that resemble that, because I think it's still just, it doesn't sit well with many people. It's a good analogy there, Ma. Last one on this segment comes from No Doubt. Says, Robert, my kids are not allowed to get a tattoo until they are 18 because they can't make permanent changes until they reach adulthood. Why would I allow them to change their sex? Well, No Doubt, it's because I think the common response is because you're ignorant and you don't know how this all works. You don't have the ability to dictate somebody's gender to them. I mean, how could you possibly do that as a parent? It's this whole woke culture. Let your kids just decide. Well, what kind of a parent are you? What if your 8-year-old wants to go get a skull tattooed on his forehead? What kind of a person are you? You are not acknowledging their experience in this world. Give them the keys to your car, get them a bank account, let them use whatever drugs, drink whatever alcohol they want, pump themselves full of hormones. All right.